Okay, Chapter 4, Medical, Legal, and Ethical Issues. And as an EMT, obviously there's going to be some legal issues that will challenge you as you care for your patients. But there are also going to be some ethical issues as well. Ethics, as we'll see, is a societal norm, something that is believed to be reasonable in a society where morals are more of a personal thing. Certainly we gather many of our morals from our ethical environments that we live in, but we'll talk more about that in this chapter. We're also going to look at scope of practice, patient consent and refusal, and some other legal issues as well. Scope of practice is a document that many states adopted a national scope of practice several years ago, and Iowa was one of those, where the reason for doing that is to make sure that an EMT from Iowa would be very similar to an EMT from South Dakota, Nebraska, Kansas, Missouri, wherever. So the whole purpose of scope of practice is it's a document that contains all the skills that as an EMT you can perform. And it's important to help delineate the different levels of EMS. The emergency medical responder has a different scope of practice than the EMT. EMT has a different scope of practice than the advanced EMT, and so on. But more importantly, it helps you as an EMT understand what you can and can't do, so that you don't put yourself into a situation where you're doing something that's not within your scope, because that can lead to negligence. Standard of care is the care that would be expected from an EMT who has similar training when you're taking care of a patient in a similar situation. And standards of care are derived from scope of practice. Standards of care are also derived by educational programs like basic life support. That's an established standard of care for providing CPR. PHTLS, pre-hospital trauma life support, is a standard of care for providing trauma care. AMLS, advanced medical life support, with its basic component, a standard of care for assessing medical patients. So we derive our standards of care from medicine, and there are many programs geared specifically to the EMT and relating to their standard of care. Now, consent is something that we have to have before we can lay hands on a patient. Technically, if I show up on a scene and start taking care of my patient without getting their consent, I could be charged with assault and battery. Just because you arrive on scene doesn't mean the patient called you. Somebody else could have witnessed it and called you, and the patient may not want to be cared for by you or treated by you and may prefer to go to the hospital by themselves. So consent is permission from the patient. Now, it can be expressed. Express consent is just that. The patient asks you for your help. It also includes what we call informed consent. Informed consent is when you arrive on scene and the patient is bleeding really bad, and you say that you'd like to control their bleeding with a pressure dressing. And they go, no, that's okay. I'll just go to the hospital and get some stitches. You can inform them the consequences of not allowing you to help control their bleeding. Like, they could bleed a lot, they could go into shock, they could die. And then when they give you consent to help stop the bleeding, that would be informed consent. Now, implied consent is just assumed. And in most cases, implied consent refers to that patient who's unconscious. When you arrive on scene, if they have an altered mental status or if they're unconscious, consent is implied. If they're a child will look at different consents for those as well. Right here, children and mentally incompetent adults. Minors are not legally permitted to give consent for treatment or refusal for treatment either. So typically we have to obtain consent from a parent or a legal guardian before we can take care of a child, with these possible exceptions. In loco parentis, which means in place of a patient, or excuse me, in place of a parent, that would be a situation where we could care for this child in situations where the child may have a life-threatening emergency. That is almost like implied consent as well. If this child has a life-threatening emergency, consent is implied, that if a parent were there, they more than likely would want you to take care of their child. And then emancipated minors, there are those children who at the age of 15, 16, 17 may leave their home, get a job, emancipate themselves, no longer under the care of their parents, and they are able to make consent issues on their own, as well as people under the age of 18 in the armed forces. So if you have a 17-year-old who's in the armed services, then they can issue their own consent as well. Again, exceptions to consent would be a life-threatening illness or injury. Now, if you have a 15-year-old who has a baby, certainly that 15-year-old is considered an adult at that point and can make consent issues about her care as well as her baby's care, and then minors in the armed services. Adult patients incapable of informed decisions about medical care, the consent in those cases may have to be either implied because a life-threatening condition exists, or you may have to get consent from a legal parent or guardian. We will have those patients sometimes that do not want to be transported. If you truly believe that they need to be transported by ambulance, then that can happen. Usually involves law enforcement. Usually the rationale for putting a person in protective custody so that they can be treated is that they pose a threat to themselves or to others. Sometimes you may have to get a court order. And again, we're usually going to bring in a social worker or a mental health professional or a police officer in order to get the patient to consent to transport to the hospital. Restraining patients is a very challenging task, and one that requires a protocol of its own. Should you work for a service and you do have to restrain a patient, there should be a protocol that outlines what kind of restraints you can use, how you can restrain them, how often you need to assess the circulation in their restrained limbs, how often you need to take vital signs, the reason you restrained them. All those things have to be documented in order to protect yourself. Patients may refuse care. Just because we're there to take care of them doesn't mean that they have to abide. If I am awake and oriented and I've been informed of the consequences of not receiving care, I can say, no, I don't want that care. I'll give you a good example. I had a law student who while out drinking and smoking marijuana, he and his buddies ran their car into a tree, and he had a scalping injury where much of his scalp was torn back, and he was bleeding quite heavily. And when we arrived, he was spouting law as a law student would. I know my rights. You can't touch me. Yada, yada, yada. stay away from me. And I'm sure he was trying to cover up the fact that he was intoxicated and stoned. But I said to him that you're right. You're absolutely right. You are awake. You are oriented. I'm going to tell you that if you don't let me care for the bleeding coming out of your scalp wound, that you will, could go into shock, could even cause death. And he said, I don't care. You can't touch me. I know my rights. And I said, again, well, you're absolutely right. But here's what I'm going to do. I'm just going to wait for you to bleed enough to where you become unconscious, and then it's implied consent. And so if they're awake, they can refuse care, even if that care could lead to the loss of their life. But they have to be informed. That's the key. That if you go to treat a patient, control serious hemorrhage, and they say, nope, I don't want that, you need to let them know what the consequences are of not having that done. They may have a broken bone. Well, I don't want it splinted. Well, okay, if I don't splint it, there's a good possibility the bone could poke through the skin, good possibility the broken bone ends could lacerate a nerve, an artery, or vein, all those things. You have to inform them of those things and then let them make their decision. In that case, when a patient refuses care, they're going to have to sign a release form, and every service has some sort of release form that's been under legal review and should provide you a good amount of protection, but you still may be liable, and that's the kicker here, is that when you have a patient who you think is okay, they know who they are, where they are, a general idea of time, and they're telling you they don't want treatment, and you leave them, even though they signed a release form, and then something bad happens to them. There'll be a lot of stuff thrown around trying to make you guilty of abandonment or not caring for the patient. So you have to be careful. You have to document their level of consciousness. You have to have a witness when they sign the release form. You have to indicate that you've informed them of the consequences, and typically that's on the release form as well. You have to allow them an opportunity to call anytime, go to the hospital by themselves, see their doctor, boxes that you would check off on this form as well. When you believe that a patient needs care and they're refusing, you need to take all the possible actions to persuade the patient to accept the care and transport. So spend some time talking with them. Find out, maybe why they're hesitant of, going in to receive care. For some, it might be cost. For others, it might be like the elder patients are often afraid that if they leave their home and they go to a hospital, that they won't ever come back to their home. So listen to them and try to determine why they're refusing care, and then inform them of the consequences of not going to the hospital. You also can call medical direction, and maybe if they don't want to listen to you, maybe they would talk to the physician on the phone. Maybe you involve another family member to help convince them that they need to go to the hospital. And as a last resort, if you're certain that leaving this patient, they could harm themselves or others, then you want to get law enforcement involved. And if there's reason to believe that they could harm themselves or others, law enforcement can put them in protective custody for 24 hours till they have a court assessment. And in protective custody, the law enforcement officer could, take them to the hospital. The big problem about taking patients to the hospital without their consent is certainly you could be charged with assault or battery. When, as I had mentioned before, when a refusal is how the call is going to end, and you have the patient sign the refusal form, you sign the refusal form and get somebody else or a witness to sign the refusal form as well. And always let them know that, hey, you can change your mind. You can call us anytime and we'll come back. If possible, have somebody stay with the patient to make sure that they, the patient that's having chest pain and refuses care, and you're really concerned that they're having a heart attack, and if they're alert, awake, and oriented, and they've been informed, and they have that right to refuse it, and they're really not a harm to themselves or anybody else, you have to leave them there after signing a release, but you certainly want somebody maybe to watch them in case their symptoms get worse and they could call 911 right away. And document. You just really need to document your attempts thoroughly, because should something happen after you leave, you don't want to be charged with abandonment. Now, a DNR in a do not resuscitate order is a legal document that expresses the patient's wishes if the patient is unable to speak for themselves. Now, a DNR may be part of what's called an advance directive. Many people, when they go into a hospital, will have an advance directive or obtain an advance directive while they're in the hospital that in advance states the type of care they will allow and care they won't. It may also be part of a physician order for life-sustaining treatment. Is another term that's surfacing. And there's also something called a living will. Living wills are much like a advance directive. The issue with most of these documents is that if they're signed by the patient and a lawyer and you respond, it really depends on the language that's in there. If it says, like in Iowa, a advance directive signed by a lawyer and a patient would say something like, if my disease is terminal, I do not want to be resuscitated. Well, you and I can't determine whether their disease is terminal. That's something a physician has to do. So a physician would withhold resuscitation. We couldn't withhold resuscitation. Now, where we can withhold resuscitation is a valid do not resuscitate order. And a do not resuscitate order is signed by the physician and the patient. And the patient would have that order with them, near them, or they may be wearing a universal identifier like a medic alert necklace or bracelet that says DNR on it. In those cases, if we have a legitimate DNR, we do not have to begin resuscitation. Negligence is something that should have been done that wasn't, or something that was done incorrectly, or you also can add negligence as something that was done that is not within your scope of practice. Now, in order to prove negligence, you have to prove that the EMT had a duty to act. And that's pretty easy. If you're carrying a pager, if you're on a roster and the pager goes off, you have a duty to act. And then you have to prove that you breach that duty. And that can be easy as well. And to prove that there was a breach of duty, you just have to prove that the EMT failed to provide a standard of care. Because we have standards of care. If somebody is suffering from life-threatening hemorrhage, the standard of care is a tourniquet. And if you did not apply a tourniquet and you're being sued for negligence, a jury of your peers, people with your similar background, your makeup, your training, your education, your experiences, would determine whether or not they would have applied a tourniquet in that particular situation. And if they believe you did not follow a standard of care, then you had breach of duty. They also then have to prove proximate cause, and this can be a challenge. Proximate cause is that the patient suffered harm because of your breach of duty. If they can prove that, then they've got their negligence case proven. Most negligent EMTs may be required to pay the damages, and these lawsuits are typically in the millions. They typically don't go to court until 2 or 3 years after the event. Depending on the situation, insurance companies may just pay up, and they may come back and try to get money from you as an EMT. So the best way to avoid a negligence lawsuit is to always do what's in the best interest of the patient. It's pretty hard to defend, not doing something just because this or that. But it's pretty hard to prosecute an individual who, within their scope of practice, is doing what they believe was in the best interest of the patient. Res ipsa liquitor, the thing speaks for itself, is also, this is more an implied negligence. And it's more in civil cases where they don't have to prove beyond a reasonable doubt that what you did caused them harm. They just have to prove that perhaps what you did was negligent. Let's say, for example, you didn't put a cervical collar on somebody who was complaining of neck and back pain. They don't have to prove without a shadow of a doubt that that's what caused their paraplegia or quadriplegia, but it would seem reasonable that if you complained of neck and back pain and they didn't immobilize you and you suffered a serious injury, then probably what you did, not putting the collar on, was the cause of that injury. So it's not necessarily black and white, cut and dried. It's just circumstantial. Now, your duty to act is your obligation to provide care to a patient. And it's not always clear of when you act, when you don't act. As a general rule, if you're carrying a pager and you're part of an ambulance rescue squad or ambulance service and you're on a schedule and the pager goes off, you have a duty to act. If you're off duty and you're not on call, you don't have a legal duty to act, but perhaps a moral duty. If you're on duty, but you're outside your jurisdiction, let's say you're on an ambulance transfer and you've dropped the patient off at another facility in another state. You know, where I live, we take a lot of patients to Sioux Falls. So we drop the patient off in Sioux Falls, South Dakota, and we're on our way back to Iowa, and we come upon a motor vehicle collision. Do I have a duty to act when I'm outside my jurisdiction? And if I do, at what level of care can I provide care? Typically most states acknowledge your service level. So if you're an EMT ambulance and you come upon an accident outside your jurisdiction, the expectation would be that you provide care at the level of the EMT. Now, when you're in your own personal vehicle and you're an EMT, you can only provide care if you're not responding in your personal vehicle with your service. If you just come upon an accident, you can only provide care at the level of a Good Samaritan. And this prevents people from carrying drugs and IVs and King LT Airways and things like that in their personal vehicles, and using those on patients prior to the ambulance getting there. So that's pretty much how that duty to act works when you're outside your jurisdiction or you're off duty. As I said before, but when it comes to caring for patients, always doing what's in the best interest of the patient is going to be great defense. Abandonment occurs when you leave the patient with somebody of lesser training than you. So if I take the patient to the hospital and I'm leaving them there at the hospital, and I leave them with a ward secretary or a rad tech or a lab tech, that's a whole different job description. That's not a medical person who provides primary care. You would need to leave that patient with an EMT or higher. Well, failure to do so, you could be charged with abandonment. Now, Good Samaritan laws protect you from liability if you're acting in good faith within your scope of practice, and they rarely apply to on-duty people. If you're in an ambulance, if you're carrying a pager for a rescue squad, the pager goes off and you respond, you're expected to respond as a professional rescuer working within your scope of practice. And failure to do so, you could be found negligent. But when you're off duty and you respond, you're a Good Samaritan. You aren't expected to provide care at the level you would responding in an ambulance, one, because you don't have the equipment with you, but you're just required to do the training within your scope with things that may be in the area. For an example, if you are at the mall and somebody collapses and there's an AED close, well, you know how to do CPR and you know how to use an AED, and you could do those. And if somebody said, hey, you didn't do CPR right, or the AED's batteries didn't work and the patient died, you're negligent, that wouldn't hold up in court, because you're just, at that case, at the mall, you're not on duty, you're not carrying a pager, you're responding as a Good Samaritan, and as a Good Samaritan in the state of Iowa, you cannot be held liable for a bad outcome. And that includes the use of an AED, as long as what you do is not grossly negligent. If you're doing CPR with your foot, or if you place the paddles on there or the patches on their head, that's grossly negligent, and you could get in trouble for that. But if you're doing something that looks like CPR and you follow the prompts to the AED and it doesn't work, you can't be held liable for a bad outcome. So it protects you, gives you liability protection when you're off duty. Confidentiality is, what you know and what you learn about patients out in the field should remain confidential. You're going to take care of patients at their worst times in their lives. You're going to learn secrets about maybe their medical conditions, secrets about their drug or alcohol consumption. You're going to know things about people that are very personal and very private. And breach of that confidentiality in most every situation is grounds for immediate dismissal, and can be grounds for loss of your certification as an EMS provider. So what you learn about a person should be kept in strict confidence, and there are some situations where what you learn about a patient certainly can be shared with other people. Those situations include, if you're using the case in an effort to educate other providers, as long as you're not using protected personal information like name, age, address, that sort of stuff where people could identify that person, you can use that information. You can share that information. You should always share the information with the people that need to know, and those are the people that will continue to care for the patient. While we want to work with our friends in law enforcement, they have a way that they can obtain the information when they need it. They may come up and ask you lots of questions about the patient, and you are really limited as to what you can share with them. If they need information, they can subpoena the record to get the information. HIPAA, you'll hear a lot about HIPAA, and everybody will say, oh, we can't say anything about this because that's a violation of HIPAA. HIPAA is the Health Insurance Portability and Accountability Act, and HIPAA essentially protects health information. Because we know that when you write that run report, you're not the only one looking at it. The emergency department isn't the only one looking at it. It's also looked at by coders and billers and supervisors and managers. It's also part of a CQI process, your medical director. So a lot of different people look at this information, and it needs to be protected. And so when we look at sharing information, and whether or not we're being HIPAA compliant, just remember need to know. If a person has the right or a need to know that information to do their work, like a biller needs that information in order to submit a bill, then you can share that information with them. But if they have no need for that information to do their job, then it's considered protected. Some folks will wear medical alert bracelets. You should be looking for them as part of your patient assessment. They may tell you a lot about their medical condition. It may tell you whether or not they're a DNR patient. It may tell you, as in this case, the patient's a type 1 diabetic, insulin dependent, also has hypertension, and has a legitimate number stamped on the back, so you know it's just not it's a legitimate medical alert bracelet. They can be a necklace, a bracelet, could be a card, and it really will give you key information about heart conditions, severe allergies, whether or not they're diabetic or epileptic. Organ donors is a situation like here in Iowa, you can designate on your driver's license that you're an organ donor. And when you do that, then as a provider, your responsibility isn't going to be to call the organ donor network and make that link occur. Yours may be just to identify either by through family members or through a donor card or off their driver's license that they are a donor, and then make the receiving facility aware of that. Now, there are some patients that we don't transport that may be found dead at home, and it is appropriate to ask if they were a organ donor. And if they are, then helping the family make contact with the Iowa Donor Network is something that you certainly are able to do. You don't make all the arrangements, that sort of stuff. You just put them in contact with the Iowa Donor Network, and they talk amongst themselves and decide what they're going to do. Safe haven laws, that's to allow a person to drop off an infant or a child at any fire, police, or EMS station. The same in Iowa holds true for hospitals. And different states have different guidelines for the ages of children. Obviously, there are times that I'm sure there are parents that want to drop their teenagers off and just leave them there. But pretty much I'm not sure what the age cap is in Iowa, but the whole purpose of the safe haven laws were to protect children who otherwise may be abandoned in dumpsters or left on doorsteps or those sort of things and unable to care for themselves. Crime scenes, when dealing with a crime scene, remember there's a lot of evidence laying around. We have to be very careful not to disturb that evidence. If law enforcement is on scene, that's when you want to enter. If you're responding to a domestic, if you're responding to a fight, if you're responding to a situation where shots are fired or those sort of things, you want to make sure that law enforcement is on scene and that the scene is safe before you can enter it yourself. As you go in, make note of everything as you go in and try to take the same path back out. If there's a hole in the shirt, obviously don't rip through the hole to gain access to the patient's chest, because that may have evidence as well. Cut around the hole. If the patient is deceased and you're there to confirm that, we don't need the entire team going into the scene in that situation. So limit the number of people initially. Make note of where everything is and how you find it, especially if you have to move something, and preserve any evidence that you may find. So examples of evidence would be the condition of the scene, the patient, fingerprints, footprints, and microscopic evidence. If you cut stuff off in the back of the ambulance, put them in a paper bag, not a plastic bag. Plastic bags have a tendency to condensate, and that may destroy some evidence, so place it in a paper bag. Remember what you touch. And again, as I said, minimize your impact on the scene by going in and coming out the same way, and work with police on what you can touch, what you can't touch. Do you need this? Look at this first, or those sort of things. As an EMS provider, you are a mandatory reporter. It is required that you do report both child and dependent adult abuse. Domestic violence, like gunshots or stabbings or beatings, are a crime, and so you would need to report those as well. Sexual assault is a crime, so you would need to report that as well. When you're talking about situations where restraint may be necessary, the reporting requirements, it's not that you have to report that to anybody. It's in your documentation that you explain to the patient that you need to restrain them, the consequences, that restraint was the only option. You tried other things. Law enforcement is present to witness all those sort of things to protect yourself. Now you notice what's not listed here is possession of illegal drugs. While the possession of illegal drugs are a crime, it is not something we're mandatorily required to report. So the fact that you are caring for a patient and find out that they've got cocaine on them or they've got methamphetamine on them, it is not your responsibility to run out and call law enforcement and tell them, hey, this guy's got cocaine or methamphetamine or those sort of things. Your responsibility is to care for the patient. Intoxicated persons with injuries, they're not really capable of making decisions on whether or not they should refuse care. They may argue that they don't need any care, but they're not of their right mind, and they're not good historians. So, those people, you may have to be a little more creative in getting, being able to convince them that you need to take care of them. Mentally incompetent people with injuries, again, those are treated much like children. So if I have a mentally incompetent patient, regardless of age, I would need to get consent from a parent or legal guardian, unless, of course, the person was suffering a life-threatening emergency, and then consent would be implied. Okay. Now remember that the EMTs must use good judgment and decision-making skills when dealing with patient consent and refusal, because what you don't want to do is leave a patient who desperately needs your care, or be charged with abandonment. Avoiding negligence implies that you use good judgment, you use critical thinking in order to avoid that liability of being sued for negligence. And as a volunteer, even on a volunteer service, you're not immune to charges of negligence and being sued as well. So we just have to treat patients with within our scope of practice, providing what we believe is most important for the patient at that time. Treat them as we would want our family members treated, ourselves treated. Do what's in their best interest, and you should be okay. You hold the responsibility for the patient's protected health information, so protect it. Exercise care when giving this information out. All right, if you have any questions,